How are you, Magdalena? Okay. Your last? Yeah. No more snow. Sunshine and warmth. Okay, good morning. There are fewer of us today, and I seem to have succumbed to whatever virus has made its way around the law school, so this will be a shorter class. So let's remind ourselves where we were. So today, hopefully everyone stayed warm yesterday and you weren't, I hope, thinking about securities law, but I'm going to remind you of where we ended on Tuesday. We were talking about this regulation of secondary transactions under the 33 Act. And the issue here is that the sort of big picture issue is that not all transactions that we care about mandating disclosure with the 33 Act machinery, not all of those transactions are transactions that are primary offerings, right? So the premise for this material, which we're not going to spend too much time on, but the premise is that there are transactions out there where we think the 34 Act is insufficient. The 34 Act giving us anti-fraud rules primarily and ongoing continuous periodic disclosure, we say, look, the 34 Act is not enough because the nature of the transaction takes us closer to something like a primary offering, all right? So we said that the main sort of rubric under which we're going to apply the 33 Act to non-primary transactions is the underwriter sort of classification, right? So if you're not an issuer, you're probably not a dealer, although we'll talk a little bit about that, but you're most likely to be found to be an underwriter if you engage in certain conduct that changes the nature of your trading from trading to distribution. And we said that the starting point for that is 2A11 of the 33 Act. The term underwriter means any person who has purchased from an issuer with a view to or offers or sells for an issuer in connection with the distribution of any security. So the question really is, what is the difference between distributing a security and trading in that security, or just selling it, right? So that's the way to think about, kind of at a high level, the material in this section. I would say the economic intuition, which doesn't come out, this is one of those sections where there's something like 60 pages of very detailed rules. And I'll apologize again to those of you who hoped that you would get a thorough and comprehensive discussion of the intricacies of Rule 144. We'll talk about them a little bit, but we're just not, in the time constraints we have, going to be able to go through all of that material or even most of the foreign issuing material. So if you want to do more on that, we've got a seminar Ed Green teaches you can just dive into international securities regulation. One reason, by the way, this is important and why it is maybe worth you deepening your knowledge of it is that there was just a news article yesterday or last night, I think it was, from Reuters, about cryptocurrency ICOs so in the wake of Jay Clayton, probably because he was listening to our class via the webcast, had announced in February that he views ICOs as securities. Head of the chair of the SEC, Mr. Clayton, has sort of signaled that the SEC is going to be cracking down on ICOs, that they are securities under the Howey test. So in response, a lot of aspiring crypto entrepreneurs are doing what? They're closing their offerings to U.S. investors. So while unfortunately we're not going to really be able to go into the Reg S material in detail, I encourage you to read it. It is probably a growing practice area for foreign law firms, non-U.S. law firms. Probably not going to be the kind of thing you would be doing at Cravath or, Sullivan and Cromwell, et cetera, because simply these top U.S. law firms are not in the business, by and large. There are some exceptions. Cleary does a lot of international work, but by and large, top U.S. law firms are not in the business of giving opinions on foreign law. You might give opinions as to the complete non-applicability of U.S. securities law, but that's about it. So I think it's kind of unfortunate that we don't have the time to go through it, but it's not really going to make that much of a difference to day-to-day practice. What I do want to focus on, though, is just the rest of the material here under the underwriter sort of rubric. And I want to point here, remember we said yesterday that kind of the concern here is defining participation in a way that goes beyond just the economic definition of reselling, right? Because from an economic standpoint, there's really no difference between reselling your securities, selling your securities, and distributing those securities. When we move from the primary market setting, where you have an entrepreneur who has some kind of private information, we suppose, about the firm, when we move from that setting to the secondary markets, where you might have a controlling shareholder like Mark Zuckerberg selling shares of Facebook, or you might have even institutional investors selling shares. At the end of the day, they're just selling shares, right? So the challenge legally is to find some kind of line that separates the mere resale, the mere selling of shares, from something that rises to a higher level called distribution. We're going to sort of unpack that a little bit today, but before we get into the nuances and the intricacies of the law here, I do want to point out economically there actually is a distinction worth keeping in mind, right? And that is that in many settings, these sorts of primary market transactions might be quite difficult to facilitate absent a secondary market player who plays the role of an underwriter. So Andrew and I were talking about this yesterday. You could imagine that, if we're talking about Spotify, and for those who are unaware, let me just say that it's always good to read the news, just in general. I think I said that at the beginning of the class. So for those who are unhappy that I'm talking about Spotify, really you should just, because it wasn't in the readings, you should just read the news. And what I'd say about Spotify is that it's an interesting case because Spotify, like some of the settings we're reading about in the readings, involves a company trying to raise capital without an underwriter designated as such. And remember, what the underwriter does is not only stand ready to purchase the shares at a particular price, injecting liquidity into the market, but the underwriter also serves as they put their reputation on the line, and because of the operation of the due diligence rule under Section 11, the underwriter's involvement implies a sort of how should I put it, a signal to the market that we have in fact looked at the books of this issuer. And while it could be that the price is too high relative to the true value of the firm, that gap is likely to be relatively, small, right? The idea being that if we've gone through the documents with the sort of fine-tooth comb that we have to apply in the due diligence process, right, in order to claim the due diligence protection in a Section 11 case, that while it might still be the case that Facebook is overpriced or Blue Apron is overpriced, it's not likely to be the case that there's some secret out there about Blue Apron or Facebook that would make the company worth half of its market value, right, or 75%, less than 25% of its market value. In other words, there's this kind of cap on the information asymmetry that the involvement of the underwriter provides. Then you have to say, okay, if that's the case, then a company like Spotify, who sells into the market without an underwriter, that company loses the benefit of that inference, right, of the market being able to rely on an underwriter who's done their diligence. And as a result, you might really worry that a company like Spotify has some kind of skeleton in the closet that makes it worth a lot less than the price at which it starts trading. And as a result, you can imagine that there would be players in the market like a Goldman Sachs or a JP Morgan or even an informed investor, or let's say a sophisticated investor of some type, like a hedge fund, who would take it upon themselves to try and reassure the market that this is not the case, right? That by our participation, by buying essentially the stock of a company without an underwriter, we're sending a signal to the market that we're not going to put so much capital on the line if there is a skeleton in the closet. So one way to think about the Spotify experiment, if you will, is that we're just replacing the role of the underwriter with a market mechanism, right? So it's a little bit of a sort of laboratory experiment to see how effective other market participants can be at sending the signal that the firm is worth something, right? That the firm is not, that Spotify is not actually a $5 company selling for $50. But that actually, it might be a $40 company selling for $50. It might be a $60 company selling for $50. But that if we're participating, then our participation means something. It means that there's probably not a lot of bad information out there, bad information hidden behind closed doors, right? So in that case, the question is, economically, if you're functioning in a way that's similar to an underwriter, do you raise the same sorts of, does your activity in this regard raise the same kind of concerns that motivated our regulatory regime for underwriters? Namely, the possibility that you might be essentially buying, sending the signal, but more or less sort of dumping low-quality shares on the market whenever you sell. In other words, could it be that the trading activity of players like these, sophisticated investors, serves to mislead the market? Because when they take a position, when they hype up the stock, when they say Spotify's a great investment, you should buy, they are effectively signaling to the market that this is worth something. But then when they sell, they might in fact be selling the lower quality firms. And how would you know, if you were on the other side of the deal, whether or not you would be facing an informed, sophisticated investor like this? And it turns out that this concern is especially heightened when we're talking about this kind of ad hoc underwriting or ad hoc participation. And that's because trading markets are by and large anonymous. So unlike the underwriting setting where you have a non-anonymized role here called the underwriter who's building a book of business, who's on the line under Section 11, and this kind of loose, informal, ad hoc participation, so to speak, right, in making the market for this stock that hasn't gone through the underwriting process, let's say, you have the risk that because trading markets are anonymous, if you're on the other side of the deal, you don't know if you happen to be facing an informed seller, right? It could be that, Goldman Sachs might be talking up Spotify while actually selling it, by and large, was selling most of their portfolio at this inflated price, and you're the loser. When you go back to think about the financial crisis, this happened a lot. Goldman actually structured, if you heard of the Abacus deal, sort of structured these deals so that they profited if the housing market crashed. So it's very rational to worry that in an anonymized trading market, this sort of ad hoc underwriting can be bad for uninformed investors. And of course, we know that the consequence of that is that prices, bid-ask spreads will be wider. We talked about this earlier in the semester. And there could be some sort of profit to informed trading. That is to say, maybe this is a kind of compensation for these underwriters. But it's this concern that motivates the regime we see here in Section 2A11 and the case law that we're looking at, which is sometimes your mere participation in the secondary market raises the sorts of information asymmetry concerns that motivate us in the primary market. And we think this effectively disclosure regulation is warranted. Because remember that if you are deemed to be an underwriter under Section 2A11, under this definition that I have on the screen, you face Section 11 liability for misstatements or omissions in the prospectus. More fundamentally, Section 5 prohibits trading, more or less, or selling or offering to sell a security unless a registration statement has been filed. So for unregistered securities, you could be in real trouble if you are buying and selling in the secondary market. But even for like your Spotifys of the world that are filing IPOs, so to speak, that are filing registration statements, you might be on the hook for any misstatement or omission that Spotify has made, right? Now that's massive liability if you're just participating in the secondary market. All right? Does everyone understand this? I want to make sure you're all on the same page as to why this matters. Yes, Davia. Yeah? Yeah. So, Spotify starts selling its equity on the public market, and there's a price. The price is $50 a share. And it could be that Spotify knows that in 2 weeks, the music industry has decided to terminate all of its relationships with Spotify. And as a result, the company in 2 weeks will be worth 50 cents. So if you're participating in the secondary market, meaning if you're selling Spotify, all right, at $50, the concern that's motivating this conversation is, are you functioning effectively like an underwriter, and that what you're doing is essentially offloading the risk that Spotify is worth nothing onto the general public? And unlike a traditional underwriter, that risk is heightened in this case because members of the public who buy at 50 don't know, because we have anonymized trading markets, that they might be facing an informed seller on the other end. And so it's a particular specialization of the broader information asymmetry problem, right? The broader information asymmetry problem is that you have informed buyers and sellers. But in the case of, particularly a company like Spotify that hasn't done an IPO, you would be even more concerned that those who are participating in the market might be participating on the basis of some non-public information, because you don't have an actor like a Goldman or a JP Morgan who's serving as an underwriter, who's on the hook for Section 11 liability if, in fact, it turns out that there was some undisclosed fact, like the fact that the music industry is cutting its relationships with, cutting its ties with Spotify. Does that make sense? So in the case of, so why you might be concerned, a lot of these underwriter, sort of statutory underwriter cases arise because we worry that the secondary market becomes a vehicle to offload companies that are worth far less than they actually are. And unlike the primary market, we don't have a player, an actor on the line whose job it is to be, putting themselves out there and held liable under Section 11 for that kind of thing. Does that make sense? Yeah. Other questions? Is the big picture clear to everyone? Yes. Let me get to follow up, and then yes. Right. So we don't know, right? So the idea is we don't know, but if we hold some players under certain conditions liable as underwriters under Section 11, then the liability standard is much easier to satisfy because we don't need to show, as we'll learn next week, any kind of scienter or mens rea requirement. We don't need to show fraud, that fraud has occurred. We merely need to show, as you remember from our conversation of Section 11, that there was a material misstatement or omission. And if, in fact, the nondisclosure of these contracts in this case, let's say the termination of contracts with the music industry, just to give a hypothetical, if that fact would satisfy Section 11, then the only recourse a secondary market player would have is a due diligence defense if they're viewed as an underwriter statutorily, and that's going to, of course, not be satisfied. So what that does is heighten the bar. Right now it's really, really risky to participate, to trade in the Spotify case, let's say, because you might be on the hook for Section 11 liability. Much, much easier to nail you under Section 11 than 10b-5. All right, does this make sense to everyone? What's motivating this is a concern that in these cases, there are cases for which we're really skeptical that secondary market participants are trading, in a manner that's truly like a secondary market trader, right? That there's a sense that in some settings, the secondary market becomes a kind of replacement for the primary market and augments the primary market, right? And Spotify is a great example in why the concern around becoming a statutory underwriter has arisen in that setting, and why in some of the cases that we read and we'll look at, the court is concerned that the way you structure the transaction should not allow you to sort of, basically escape Section 11 liability, Section 5, merely because it's not formally a primary issuance of securities, right? So that's the concern. Is this clear to everyone? In the back, yes.
So I'm just curious about the anonymous nature of the market. Like, why? Can you just speak to the policy reasons as to why the market would allow traders to be anonymous?
Yeah. So great question. So a really fun topic we haven't had the chance to, and I maybe am thinking of sort of allocating the time on this class. It's way too much material for such a short amount of time. But a whole section of the regulation of capital markets are institutional details and structures, like whether a market is anonymized or not, and how our security markets actually function at the level of, what do you see? You want to go buy a share of stock of Apple. What are you given? What information are you given, right? So Merritt Fox has a great class with Larry Gloston. You can take the regulation of capital markets where they really dive into this. It's actually very relevant to securities law, even at this level, because anonymization is the basic rule of thumb in in the capital markets. I would say, absent very limited exceptions. So if you are a blockholder who acquires more than 5% of a public company's shares, then we have Section 13 that requires disclosure of the 1934 Act that requires disclosure of your position, either on Form 13D or Form 13G. And there is, in fact, trade-by-trade reporting for corporate insiders on Form 4, and this is under Section 16 of the 34 Act. And investors who own more than 10% of the company shares must disclose individual trades. But other than that, all other trading, by and large, I can't think of other exceptions at the moment, all other trading is anonymous, right? And one reason, so why is that? Is a really interesting question. It goes back to the role of brokers, right? Brokers were facilitating trades on behalf of clients, and often you wouldn't even, it didn't really matter who the client was. The broker's just standing ready to buy or sell. If you go back historically to the New York Stock Exchange, what did this market look like? It looked like brokers and dealers transacting without regard to the underlying principles. So in that case, it kind of makes sense, right? It's not as interesting who's buying or selling, because a broker might say, I have a customer who wants to buy 100,000 shares of a company. It doesn't really matter from the standpoint of the counterparty who that customer is. Now, and sometimes brokers can fill orders themselves among their customers without even going out to the market. Right? So these are all fun details of kind of market microstructure, sort of how exactly transactions are executed. But the premise of all of this is that, in fact, all that matters is that you're willing to buy or sell at a particular price. It doesn't really matter who you are. That is very different from most markets where we have, in fact, non-anonymized contracting. Right? So most contracts are non-anonymous. We know who the counterparties are. By the way, fun question to think about. Is a security a contract? So what is actually happening in securities markets? Is the purchase of shares the formation of a contract? Right. So think about that. It probably isn't. By and large, the purchase of shares might be more akin to purchasing property, but it's not clear exactly what the purchase of equity shares actually is legally. Yes, Christian.
So would this system for the underwriters in secondary markets increase the riskiness of trading in secondary markets for sophisticated investors? And if so, how would that impact the price of the security?
Great. So Christian asks, what's the net impact on risk? Because we have potentially Section 11 liability floating out there for anyone who, crosses one of these somewhat amorphous, ambiguous thresholds that we've been reading about and becomes an underwriter. Sort of by act of God, you are now an underwriter. So isn't that a risk? So yeah, it is a risk. It's really a risk if you don't have an underwriter in your transaction. Because if you have an underwriter in your deal, then in fact, it's probably pretty clear that if one of these famous investment banks has done due diligence, that there probably isn't a skeleton hanging out there. Okay? So the real question, and this is the big question surrounding Spotify, is how much liquidity is there going to be in Spotify stock? Because, I don't want to be deemed an underwriter. That's a risk. Okay? But more fundamentally, who is vouching for Spotify? Who is vouching for the integrity of their business model? Who is vouching for anything? We don't really know. We have some actors. So the theory is that for really hot tech companies like Spotify, they're already receiving tremendous infusions of cash in the private capital markets, that sophisticated investors like VCs and hedge funds are already out there sort of vouching for these firms, and that they wouldn't be pouring so much cash in if that weren't the case, if this weren't really a company worth the price that they bought it at. Because remember, they don't make money if you're a sophisticated investor in the private capital markets. You don't make money buying effectively shares of Spotify in a private placement or a private, let's think of like a VC transaction, which would be completely exempt, right? We learned about those exemptions. So you don't really make money, right, if you buy it effectively, $50 a share, and then you can only sell in the IPO at $10 a share, right? So the idea that some investors have gone out and, in the private markets at least, put their weight behind the company is supposed to offer some reassurance. Now, of course, you could say, well, first of all, there can be transitory mispricing. So in the short term, they could just be dumping their shares out. With the moment it goes public, all the all the smart money sells and the dumb money buys, and this happens very quickly, and people don't realize it until the 2 weeks go by. And query whether that would raise any anti-fraud concerns. At the end of the day, probably not, right? Because I am perfectly entitled to sell. We'll talk about sort of what is material non-public information. But if I don't know something bad about the company that is non-public, if I'm just sort of skeptical about the valuation, I will sell. And so the real question isn't necessarily whether there's risk, because there is risk, but whether that risk makes its way into prices. And if not, why not? Right? So why is it that Spotify gets a price anywhere near its valuation, its true value? It should be a huge discount applied immediately because, in fact, it's a very risky deal to buy, right? But once the price has adjusted, there isn't as much risk, right? The risk is far removed. So one thing to keep in mind, so Matt Levine had this great column yesterday. Where's Elliot? There you are. Hey, so Elliot and I were talking about this. Matt Levine's column about sort of securities law as a sort of judge and jury, kind of a legal system. Matt Levine's a really smart guy, by the way, and I like his columns. For those who don't know, he went to law school and worked at Wachtell and Goldman, so he's smart. And I had an email exchange with him after his article yesterday, because what he said in the blog post was basically, or the column was, we can think of market reactions to news like the Facebook Cambridge Analytica scandal. We can think of that as kind of the market passing judgment on the firm. And that judgment need not actually be tied to any underlying substantive violation of law. So Facebook's defense to the Cambridge Analytica scandal is, well, we weren't hacked. There was no violation of law or sort of intrusion into our systems. At most, this was maybe a breach of contract, but that's it. And Matt's point was, well, the market has reacted negatively. Therefore, the market has passed negative judgment. The market has decided that it was bad. And we can think of securities law, he argued, as a kind of crude but fast and efficient legal system. That's a cool idea, right? That's a really cool idea. It's too bad he's not an academic. That's a cool idea. I like that idea. He's probably making more money, so yeah, that makes sense. So think about that, right? And so I had this email exchange with him, and I said, look, Matt, that's really cool, but the problem is that your legal system, your rudimentary Robinson Crusoe, the market judges you immediately, your system basically depends on price changes, not prices themselves. So if, in fact, it turns out that the market, well, let me say it differently, prices change when investor expectations are disappointed or surprised, right? When the reality is different than expectations. So if you think about the market's reaction to Facebook's Cambridge Analytica scandal, one way to interpret that is to say, well, the market was negatively surprised, but at some point it's going to start expecting that all public companies like Facebook in the tech sector have done bad stuff with people's data. And when that happens, in fact, you could see a positive price reaction. Right? Because this is important to understand, right? Because the market has kind of baked in to the price the possibility that Facebook is doing bad stuff with people's data. That means Facebook stock, if you think about it even from today, is worth less than it was yesterday. But tomorrow, if there's more bad news coming out, that could actually increase the price. Does everyone see this, right? Because my expectations as of today are that that Facebook is doing really bad stuff. And if it turns out that Facebook is doing bad but not really bad stuff with people's data, that's good news relative to my expectations. Does everyone see this? So Matt's sort of system, securities law as a kind of judge and jury and executioner of companies, is really all about investor surprise or sort of deviations from expectations. So it's kind of could have some perverse consequences that companies who succeed in sort of lowering expectations sufficiently are those who are rewarded by the market when news comes out. I'll reread his column and think about that. So in the case, so why does any of that matter? Well, let's go back to thinking about prices in this setting. So if the price of, let's say, a Spotify is sufficiently low because we've internalized, Christian, these expectations, we've internalized these risks, that in fact there could be some bad skeletons in the closet, then the risk going forward, once the price is low, is actually quite small, right? Because now there's only upside. I mean, you bought it at a very low price. So at any moment in time, you can kind of think that intertemporally it really matters, right? That at any moment in time, the risk-price relationship can vary. It could be that today, because the price is really high, the risk is huge. Once the price goes down, the risk might be much lower. Why? Because the concern that the value of the firm would be even lower than what it is much, much, much less likely to happen, right? So risk changes as prices change. So keep that in mind, and that's sort of a sidebar. Okay, any more questions on this? Yes? Ben.
Thinking about sort of perverse consequences, we've been sort of operating under the idea, I think, unless I'm mistaken, that Section 2A11 sort of creates some amount of risk for sophisticated investors who are informed and could possibly serve, like in the Spotify context, as this sort of makeshift underwriter if 2A11 weren't there.
Yes.
But to me, it seems like it could harm smaller issuers as one of the major things here, because I've always assumed, as we've been doing this, that the underwriter is subject to heightened liability because they're informed because of their insider status, which has to do with contractual privity, which is something that in the Chinese benevolent case they said is not dispositive in this type of thing.
Right.
But in terms of not everybody is Spotify. I would imagine that more people who would rather use some sort of sophisticated investor if they could without having some contract between them as an underwriter type, if 2A11 weren't there, is some small issuer who doesn't want to have to pay for the costs of traditional underwriting, registration, et cetera. That seems to me to be who's getting penalized here by this rule.
Great. So the question, great. So I think that's exactly right. So very good. So the question is, are those companies even able to go public? And so are they? I mean, one way to think about it. So you said penalized. They could be getting rewarded by this rule, because what this rule is doing is actually creating liquidity for them. I mean, absent this rule, nobody would buy their stock. Right? Because the fact that you're not putting an underwriter on the line, and yes, you, issuer, have strict liability, but by the time you get sued, you're probably worth nothing. So you're kind of judgment proof, and your executives are probably worth nothing anyway, like also, right? So, you haven't put underwriter on the line. I'm not going to buy, GNC biotech firm that supposedly has cracked the cancer DNA, but isn't confident enough to let Goldman Sachs look at its business. I mean, I'm not going to pay anything for that. It's probably worth zero. Now, what 2A11 does for a company like that is say, look, to investors, look, you don't have to worry, because if in fact, Goldman or one of these analysts are out there hyping the company up, and there is, in fact, someone who's buying the shares, don't worry. That secondary market player might be held liable for violations of Section 11, meaning there is an actor out there who you can sue. You can think about it as introducing a non-sort of judgment-proof creditor to the game, right? Okay, so that could increase liquidity, right? So it's not clear that it's not clear that 2A11 actually reduces liquidity in the market, right? It could increase it. Yeah, but the key, let's, any more questions on this? Because I want to go ahead and move to some law, believe it or not. Okay, all right, great. So Hopt, all right, so Hopt is kind of an interesting case because so most of these cases are not really about that, right? So while I agree with you, Ben, that this is like potentially sort of changing liquidity for issuers, the question is, traditionally, how has this come up? And the answer is, well, it's come up in settings where sort of it looks like some insider was trying to dump kind of worthless crap on the market, right? That's sort of the setting that this has traditionally come up. So Hopt is this really entertaining case involving dividends and whiskey, which the better days in the 1940s, right? So you could have been a shareholder of Park and Tilford and gotten a dividend in whiskey. And I guess that was so popular. This is on 507 of the casebook. That was so popular with their investors that the price went up from 58 to 96. Now that's a massive increase. I guess people, because there were wartime shortages, I guess, on whiskey, if you got a whiskey dividend, then that was the only way you were able to have a good time. So there we go. So that's great. So he's giving these dividends out, and the question is, so we got this broker, right? So the broker is Ira Hopt and Company, and Ira Hopt and Hopt is facilitating these sales of stock. So essentially, yes, they're giving a dividend. That creates this, in whiskey, that creates this massive demand. And Mr. Schulte, or his interests, right, these trusts that he owns, are sort of offloading, unloading their shares, sort of saying to people, here, you can buy our shares. And that's, I guess over a 6-month period, they sold about 93,000 shares of stock. And the question is whether the broker, this Hopt firm, can be held liable under Section 5 because they are an underwriter. All right, so this is a little convoluted, but let's try to trace this out. So basically, right, we know that Section 5 does not apply to transactions by anyone other than an issuer, underwriter, or dealer. The term dealer is defined in 2A12 as including a broker. So why is there any question? Why is there any question, for those who read the case, why is there any question about whether or not Hopt is an underwriter? Why are we even talking about underwriters, why are we talking about a broker as an underwriter? Why does that matter? Okay, this is why your class your friends who are taking this next year are going to get put on panels and randomly called on. Yes? Yes?
Because Schulte's owning 92% of the stock, and the broker is distributing on behalf of the controlling shares.
Right, great. So that's right. So the broker is facilitating the transaction on behalf of the controlling shareholder. Informally, why does that make the broker not a dealer? Yes, Christian.
Wasn't the issue that there was a brokerage an exemption for brokers in 4.4?
Yes, exactly. So in the convoluted mess that is the statute, so dealer means, any person who engages as a broker, but 4.4, well, I'm not going to page to it, but 4.4 exempts brokers' transactions for customers, Brokers, well, now it was 4.2 in the case, you see this in 507. Brokers' transactions are exempted when they're executed upon customers' orders on any exchange or in the open or counter market, but not the solicitation of such orders. So the idea is that if you are a broker sort of faithfully executing your customers' orders, then you're not swept in to the definition of dealer. You're not a broker for purposes of Section 5 with respect to your brokerage activities. You can nonetheless be found to be an underwriter, though, right? Because it could be that you are participating nonetheless in the distribution of the shares. All right, so what was the So what was the question here, and what did the court decide? Continuing our voluntary participation model. Alistair.
Yeah, the court decided that Ira Hopkins and Company was an underwriter, notwithstanding the fact that there were some restrictions on the terms in which stock would be sold.
Yeah, great. So what was the reason? Why were they an underwriter?
Primarily, it was because they played a primary role in the distribution of the stock to the public.
Yeah, but before that, okay, that's right. So let's just start systematically with the statute, with the text of the statute, right? So the term underwriter means any person who has purchased from an issuer with a view to, or offers or sells for an issuer in connection with the distribution of any security, or participates or has a direct or indirect participation in any such undertaking, all right? Now, the key starting point in the analysis is, as used in this paragraph, the term issuer shall include, in addition to an issuer, any person directly or indirectly controlling or controlled by the issuer, or any person under direct or indirect common control with the issuer. The reason why the controlling language matters is that they're actually selling on behalf of Mr. Schulte, right? So Mr. Schulte or his interests are selling. He, indisputably, is an 8% owner of the firm. 92% owner of the firm, and so indisputably owning 92% of the firm makes you a controlling shareholder. So Mr. Schulte is in fact controlling the issuer. Therefore, sort of formally, keep the formal steps clear, the Haupt, the brokerage firm, is not selling on behalf of Park and Tilford. It's not selling the shares on behalf of the issuer. It's facilitating a secondary market transaction. Pay careful attention to this, right? You have essentially a private actor, Schulte and his interests, who are selling their shares on the open market via this brokerage firm. This is not a firm issuing equity. Okay, make sure this point, this is important. Make sure this is crystal clear. This is not Park and Tilford selling shares to the public at a price, receiving cash and putting it in the corporate treasury. This is Mr. Schulte selling his shares on the secondary market at a secondary market price to a buyer. Important distinction. So it does not turn you into an underwriter if you are participating in a distribution, okay, unless you can link that distribution to the issuer. All right, or let me put it differently. Mere participation in a transaction is insufficient to turn you into an underwriter unless you can link it to a distribution or a purchase from the issuer. But the term issuer is expanded statutorily to include people like Schulte who are controlling shareholders. So controlling shareholders are swept in to the definition of issuer for purposes of the underwriting statute, of the underwriting definition. And thus, okay, the key point here is that, and this is what we saw in the bottom of 508, Schulte, owning in excess of this shares, had formulated a plan to sell his stock over the exchange in 200-share blocks, and this trust had specifically authorized the sale of over 73,000 shares, and the court says, look, we don't need a predetermination of the precise number of shares, but when you sell such a large block, it clearly seems like there's a distribution, and in fact, the broker in this setting is facilitating this distribution, and thus they are statutorily, so to speak, transformed into an underwriter. Okay. Is this clear? Right? So it actually turns out that the quantity isn't so crucial. We'll see more about that in a minute. But there's something about the nature of this transaction that concerns that is concerning. And this is not, I said, the court. This is the SEC. Okay, so the next question is whether or not the brokerage exemption, in fact, applies to an underwriter, right? Because even though you might say, well, yeah, the brokerage exemption in 4 for now could nonetheless immunize the underwriter's own liability. And the SEC says no. It turns out that the brokerage exemption makes it that if we look at the legislative history, there is in fact a distinction between trading and distribution, and that the purpose of the broker-dealer sort of section of the 33 Act, all of those different components of the statute are designed to facilitate trading, secondary market trading. So too bad, because in this case, it wasn't really secondary market trading, but actually a kind of block sale, and that block sale is enough to constitute distribution, and thus underwriter liability attaches. All right? Now that's a pretty fine factual line. You could imagine in other cases where the line is far less clear. One way that the line would not be as clear is if it weren't like, such a large quantity of shares. And that's really what a lot of the uncertainty has turned on, as you read. But another area where the line may be not clear, dividing trading from distribution, is whether or not you're selling on behalf of a controlling shareholder. So how much ownership is required to constitute control? And you read the A.A. Summer article, which basically says that in the Business Lawyer, which basically says, look, it's sufficient to have some ability to exercise control. That's going to turn on individual facts and circumstances. It's not necessarily 51% of the shares. And we should certainly start with ownership in the block, sort of size of your ownership block, but that is not the end of the conversation. It could be that with a relatively small block, you nonetheless effectuate control. Now, why is it that control turns out to be the threshold for looping in secondary market transactions by shareholders? It's not entirely clear. It probably has something to do with the information rationale that we've been discussing, that by sort of applying potential underwriter liability to those who sell on behalf of controlling shareholders, we think that the exercise of control makes some information available to the unputative underwriter that wouldn't be available if he or she were selling on behalf of a non-controlling shareholder. But that's a bit of a leap, right? I mean, it's not clear just because I have control that I have more information. And it could be that minority shareholders who lack control nonetheless are well informed. I have a paper that shows that activist hedge funds who often reach settlements with sort of target firms if they want to change, appoint to the board of directors pursuant to the settlement agreements, a couple directors. So they have 9 people on the board. They add 2 people on behalf of the activist. The activist certainly has no control. They have some kind of influence, but it's definitely not control. Activists might only have a 6% share of the company. But it turns out that in those cases we see apparently greater trading on non-public information, greater information leakage. And so we find this empirically, and that suggests that the concerns around informed trading by those who have sort of the desire to dump their shares on the market, that may or may not be so tightly correlated with control, right? That control is a very rough proxy for information. All right, anyone have questions on this material up to 520 of the casebook? Yes, Davia. Yeah. Right. 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 So think about it like this. If you're facilitating a transaction, if you're selling, you are a broker, so you're selling on behalf of a shareholder who does not have control. Clearly doesn't have control, 1% ownership of the company, or 0.1%, then you're clearly not going to be participating in the distribution of a security. I mean, you're clearly you're like E-Trade. You're just facilitating a sale on behalf of an individual shareholder. So sort of step one in the analysis is to say, look, remember, these are secondary market transactions. We're in a world of secondary trading. If I'm selling on behalf of a shareholder who clearly doesn't have control, then it's going to be very hard to get me in as an underwriter. I mean, almost impossible, right? maybe strange cases where there's some existing distribution going on, but by and large, it's going to be okay. So then you can say, look, what if you have a controlling shareholder, or a case where control is ambiguous? Then you have to think, okay, are there facts that weigh in favor of a distribution as opposed to just secondary market trading? So the courts seem to look to the quantity of shares. The courts seem to look to to intent. I mean, one of the comments on the end of 520, when should a broker recognize that a distribution is in progress and it cannot rely on 4.4 under Haupt? Well, in Giger versus SEC, the DC Circuit found that the unregistered sale of 0.5% of the outstanding shares by controlling shareholders and officers of a shell corporation violated Section 5 because it amounted to a distribution. Although 0.5% was a low figure, the critical factor to the DC Circuit was that the stock was moving from controlling insiders to the general public. Now, my critique of that is, look, if we're concerned about information asymmetry, it's not clear that that controlling standard really matters. Now, insiders, that matters, but control seems to be a loose proxy for information, right? So you might, after finding that there is control, or whether control is ambiguous, you might then ask whether these concerns are implicated, right? Now, even if you think under the black letter law, it's not likely to be the case that there is some participation here, you could try creatively to say, look, if there's an insider who may not actually be exercising control, maybe you can try and link, maybe it would be a stretch, but you could link their special position on the board. So one thing you might say in the activist setting is, well, activists don't have control, but they kind of have a tremendous degree of influence. And, as Summer suggests in his article, maybe, we should read that very broadly to include the ability to exercise control. And so maybe there's a sort of place here to argue for a very broad definition of control that is more tightly linked to information. All right? So again, there's shades of gray here. We have the law as it's given, but then when you step back and think and reflect, you say, well, that doesn't necessarily always make sense. And that suggests that maybe pushing the definition of control if you have a particular setting. In other words, let me say this differently. I wouldn't, if your client's asking you, I'm an activist, I'm not a controlling shareholder, can I just, sell? Or the broker's asking you, I've got an activist who wants to sell. You shouldn't rush to say you're in the clear, is my point. Right? Another way to think about this. Because it could be that the SEC will take a very aggressive view and say, look, control is really all about information, and that's what the idea here is, and so read that expansively. Other questions? Is this clear? All right, so let's move forward. Where are we moving forward to? Rule 144. All right. So the question is, can we get any more certainty? I'm not going to spend a lot of time on Rule 144. I would say read it. Basically, it is a safe harbor. It is a safe harbor for brokers facing this impossible determination of whether or not they are participating in an offering. And you see the criteria, there's 5 of them. We need to see adequate current public information. We need to see, which you can read this. It's basically for reporting companies, satisfied by and large. This is a mechanical checklist, so I'm not going to spend too much time on it. Restricted securities have to be held. This is the key point for at least 6 months. So the intuition is that I can avoid sort of participating in this kind of scheme to basically, take advantage of the general public if the player who's selling their shares has been holding on for a long time and thus has true exposure to the economic risk of the company. There are some quantity thresholds in the case of affiliates. So the key distinction, I'll just say briefly about this in Rule 144, is when you're selling on behalf of an affiliate or when you're selling restricted securities that arise from a private placement. So 144 has limited applicability. It doesn't apply to every case of unregistered securities, and it doesn't apply to all public companies like Spotify's, right? So 144 kind of captures a particular set of transactions that involve often securities that were sold by, that were awarded to employees of a company. So if you take like a Facebook, before they went private, it would give their employees restricted securities, right? So there's certainly nothing wrong with that. If you comply with the exemptions that we discussed, you can give your employees securities that cannot be resold. Remember, under Reg D, those securities can only be sold to accredited investors. So what 144 is allowing essentially is a market to emerge in these sorts of restricted securities when you can comply with certain criteria that show that you're unlikely to be exploiting your material non-public information. That's the intuition. The way that is expressed in these 5 requirements is that you're, for example, participating in the open market, that you're not selling too many. So the idea is with these safe harbors, like the prior safe harbors we saw, is to really just delineate a set of bright line rules that if you comply with them, get you off the hook. That is, they are not a distribution, but rather a trickle, as you read. So it's just a trickle of securities into the public. All right, so you can read more about that. I'm not going to spend too much more time. I want to talk for the last, bless you, for the last 10 minutes or so on Section 4.5 in the Sherwood case. So basically, this is a continuation of our conversation around regulating secondary trading. And the issue here is when you have restricted securities, that is, when you have securities that are sold in a private placement or given to employees, for example, securities that are sold pursuant, by and large, to one of the exemptions we discussed. The question is, if Rule 144 doesn't apply, or before we get to Rule 144, or Rule 144A, which we'll touch on, if we're just looking at the statute, is there, in fact, a basis for reading in the case law on public offerings? If you remember Ralston Purina in the conversation we had on what is a public offering, we discussed ideas that feel kind of similar to this question around distribution, right? So the issue here is, could you actually take the ideas that developed the judicial and administrative interpretations of the term public offering that emerged in the Section 4.1 setting, where we were asking whether or not transactions that did not involve a public offering were de facto exempt, we know, from Section 5. That is exempt full stop. The question, of course, turned on what exactly is a public offering. Now, those questions around what exactly is a public offering seem very similar to questions around what is a distribution. A distribution is kind of like a public offering. It feels similar anyway. It sounds similar. And so if we look at the legislative history, we see that there's some similarity. The Sherwood case involved an individual who had who was selling unregistered securities, and the issue was whether or not the intent of the seller could take him off the hook. You saw that in that the court is unconvinced that Mr. Sherwood sought to sell these securities with a view towards distribution. So the Section 4.5 material is kind of a judicial, think of it like we're going to sometimes be able to argue that a distribution hasn't happened because, like we argue in the public offering setting, there could be a lack of intent to distribute securities. So they're going to kind of read in a subjective intent requirement. But a key factor in the case of Mr. Sherwood was that he had held the shares for 2 years. And so there wasn't, you could argue, objective evidence of non-investment intent, meaning he seemed to be taking a long view, long position in these securities, and that seemed to reflect sort of a genuine sale that makes him more like, a market participant who is invested and decided that now is the time to sell, and less like I'm just going to be more or less flipping this company, just dumping shares on the public market so that I can profit. And so the duration, right, the duration of the holding period, we see this in Rule 144. We also see it in Sherwood as kind of convincing the court. And a kind of similar issue arises in the Gilligan-Will case, where, which we don't have time to go into it, but the idea here is we're going to apply a similar subjective test, and we're going to say, look, if we have an individual who's participating, who's selling their shares, and we have evidence that this sale is not really sort of, I'm just going to dump my shares on the market because I know something, I've learned something. They're not a trader, but rather they're selling to a small number potentially of buyers. These kinds of private placement-like resales, right, are going to get picked up by Section 4.5, right? That is to say, we're going to read in to 4.2 the logic of 4.1, which even though formally doesn't apply, why does it formally not apply? Can someone tell me why 4.1 does not formally apply to these transactions? Got it, exactly. Magdalena's got it. Excellent. It's not an issuer, right? Exactly. It is a secondary market transaction, but we're going to be inspired by the case law like Ralston, Perina, and our sort of jurisprudence on what is a public offering, and we're going to bring that in to 4.2. The SEC has kind of embraced this view that, and this is in this long commentary that begins on page, 548, maybe even earlier here, 547. And the discussion is that, they sort of like this idea that the subjective test of whether you acquired the securities with a view and that the resale is not happening with this view towards distribution, they kind of like the idea of asking whether the securities have come to rest, right? This term shows up in their description. What are they saying? Well, I'll just read a little bit from this very nice exposition on 549. Under the traditional pre-Rule 144 approach, the prevailing view of securities law practitioners was that once restricted securities had come to rest, in the sense that the resales would not be a further step in the issuer's distributive process, there should be no restriction on the manner of resale. Right? So the intuition here originally was that prior to a set of criteria coming out on Rule 144, if you bought securities in like a private placement that were restricted securities and the issuer has finished raising capital, then you can go ahead and resell those. There's a sense that it's no longer facilitating this capital raising transaction. It's kind of like, it doesn't really matter to Spotify if you went subsequently and resold those securities. The SEC kind of likes this idea that they say, we think that this traditional approach has continuing validity and that the 4.1 exemption should be available if the holder can demonstrate that he did not acquire the restricted securities from the issuer or an affiliate with a view to distribution, and that the resale is not being made for an issuer. So you want to try to show that you're not conducting the sale on behalf of the issuer. And again, as I mentioned a second ago, if he has established a sufficiently long holding period, that alone should demonstrate conclusively that the original acquisition was not made with a view to distribution. Right? So the kinds of settings that the SEC has in mind here are these sort of, the company has raised cash via private placement of restricted securities. Someone, employees or others private investors have bought these securities, been given these securities, and for a long period of time, they've held on. And the idea is that if they want to resell them to some other sophisticated investor or some other small group of individuals, we're going to kind of, we're going to reason that the securities have come to rest, the distribution has concluded, and now they are free, provided they continue to comport with these general guidelines. They shouldn't advertise on the internet. Think about a query like the emergence of shares post, second market, some of these secondary markets for restricted securities. You might just Google those. Think about how those fit into this framework. But at the end of the day, all of those require sort of strict registration. They kind of guide you. If you want to buy a share of Uber, it's not like you can just buy it, right? You need to have this kind of directed process. This is all driven by the concern that the resale of these restricted securities needs to comport with the spirit of Ralston Purina, with the spirit of this sort of, they've come to rest. We're now not funding the issuer's operations, and these are non-public, private conveyances of your shares, not a sort of widespread mass sale that implicates the concerns that drive securities law. Okay, it's worth reading about Rule 144A, which is a pretty huge market, but not particularly challenging and sort of to understand. It's often used for foreign issuers, and there is this idea of a QIB, a qualified institutional buyer. You can read about it. We're not going to have time to go into it. I'll just conclude by talking about what we're going to do next week. So this is sort of the limit, I think, of what's feasible to cover the 33 Act at any level that tries to balance law and policy. So we are going to stop here. Like I said, there's more you can read. It is kind of an endless world, right? And that's why this is just an introduction in many ways. And you can take more advanced coursework, particularly in the 33 Act. I think the most sort of interesting and contested area of securities law that gives rise to news articles, that gives rise to a massive cottage industry of plaintiffs' lawyers is really the material that begins next week. It is insider trading. It's going to be a lot of fun. I think it's going to be a change of pace, much more about case law, much more about reasoning from prior precedent. And so I will send out just to recap the readings for those who are already looking at the syllabus. Basically, we're going to do the insider trading material over the next 2 weeks. So that means sort of half of it this week, half of it next week, half of it the following week. I'm going to add the Martoma case, which is important to understand, particularly if law firm associate to be. And I'm going to add just ask you to reread Basic and Matrix in light of the material that we're studying. I am, if you are wondering sort of how the course will be kind of tested on the exam or the relative weight, I envision one question on the 33 Act, on the essay section, and one question on insider trading, 34 Act. So even though there's a lot more material that we've covered, there's just so many details, it's very hard. Those may come up in multiple choice questions, the big stuff that we've been discussing, but I will not be asking you about, some footnote or even, middle of the book paragraph on Rule 144A that we didn't discuss in class. So don't stress, but really try. My encouragement would be to really read the materials for insider trading and think hard about it. Come prepared to discuss the facts of these cases. I will ask you to talk about them, and we'll kind of change the pace a little bit and make it a little bit more sort of case common law driven. Okay, any other questions? Office hours will be resuming next week. For those who would like to come, Wednesday's looking like a good day. Maybe Monday, but for sure Wednesday. All right, have a nice weekend. Good luck for the 3Ls, so they're probably all gone already. For those of you on video, I hope it went well. All right, see you later. Hey, Divya, how are you? What's up? So you're asking, does it matter how they acquired the securities?
Yeah, because I thought when I was reading the court's holding, it's just they still seem to kind of per se hedge it. Okay, the issue is that what is it? The SEC didn't provide enough proof to support their claim.
Right.
It's not that this transaction does not constitute a violation. It's no, more so that they didn't. The SEC didn't prove their case.
Sure. Well, because that's sort of think about that as an adjudicatory setting, right? So there's litigation, but the issue here, the underwriter liability question, is around the resale. So the initial granting of the security, in as much as you're sort of thinking, okay, can we try to tell a story around the cases that are most convincing? Sure, often it involves, private placement or it involves employees, but that's not a requirement, right, formally, because we're talking about the resale. That's just sort of what is the setting that raises these concerns. It's typically when you've been given the share. That the policy concern is that you've been given the share. It's worthless to you unless you can sell it, right? So a lot of times the what's motivating the 4.5 exemption is like, look, it's just not meaningful if an employee is given a share of restricted stock and they can never sell it because they are not going to be by and large liable under Section 5. We know that, but because Section 5 only applies to issuers, underwriters, and dealers. But the underwriter, no broker will sell it for them because they don't want to be an underwriter. So how are you going to sell these shares, right? So the idea that we don't want a completely illiquid market in restricted securities is what motivates this, but that's just the motivation. At the end of the day, the test is applied to the resale itself. So the resale has to follow the long holding period. It has to be sort of not a public, very public offering, so to speak, right? It has to be to individuals. So, but that's about the resale, not the acquisition.
Okay.
Does that make sense?
Yes.
Okay.
So the resale is like, okay, it's kind of more systematic in its approach.
Right.
And I understand it, and like the whole like the long holding period. They weren't really specific, according to my memory, about like how long you need to hold it.
So the guidance that we saw was, if you're holding it for maybe it was a year, 12. If you're holding it for a long time, fine. Rule 144A has a 6-month holding period. So Rule 144A is a very attractive basis for this because it's only 6 months. That's pretty easy to satisfy, right? So if it's only 6 months, then let me just close this out. Then you may not. So you're going to try to get Rule 144 to apply, right?
Okay.
Right.
Alrighty.
Yeah.
Trying to make a
Does that make sense?
Yes.
Yeah. And if you want Rule 144 to apply, because then you only have to wait 6 months. But if not, then it's this kind of it's sort of like Rouse and Green. It's a very open-ended test. You just have to argue that the totality of the circumstances.
Totality of the circumstances.
Right.
Okay. Alright.
Does that help?
Fair enough. Yes. Thank
Yeah,
you. And just
absolutely.
one quick question about participation. Should
Yeah.
we come to you like? make
You're
sure
fine.
that we're- okay.
You're
Okay.
getting maximum credit. You come to me every class. You're good. Yeah. You're fine. Yeah. Yes.
I emailed you last week about the supervised research thing.
Oh yes.
Remember that?
Did we talk about? Do we need a?
I
I'm
didn't
just
come
trying to find your-
yesterday, but it's still there.
Yeah. Can we talk about that at office hours next week?
Yeah, so I
Okay.
was just wondering actually Wednesday's not the best day for me.
Okay.
But Monday, what
Monday works.
What other days?
Tuesday, Thursday are good days. I'm usually not here on Friday. I might be
Okay.
here next Friday. I'm not sure, but is Tuesday, Thursday work? Does that work
Yeah,
for you?
so would you prefer before this class or like after?
No, not before. Let me
Probably in the
just
afternoon.
look. Hang on a second. Next week is rough because I'm flying to Boston after class. I'm speaking at the university's data science day, and then I have a meeting with the dean on Thursday.
Okay.
So next week is tough.
Because I also have like a deadline. I probably want to have. I need to get the paperwork home before April.
Are we talking about a fall credit class?
Yeah, and it's kind of complicated.
Yeah.
So
I mean, I think we can aim for.
early.
If you want to have a
April's fine.
one-on-one meeting, we can do that the week of April 2nd.
That would work.
Okay, so why don't we correspond via email and take
Okay.
time by email?
Okay.
But I don't think I can do a one-on-one meeting today.
Okay, I'll send you an email.
Good. Looking forward.
you.
Yeah. Hi.
I just have a quick question about a rule that I was a bit embarrassed to ask the last
Well,
time.
I'm sure there's nothing embarrassing about it.
With the Rule 10b-5 discussion on the practice question, that comes in if you say, is this a forward-looking statement? And then if you say, is Section 11 wouldn't apply, so it takes it out of that. But then you can still be liable under 10b-5.
Based on what we know as of the practice question, right?
Okay,
We
so
haven't done
that's-
insider trading.
Alright,
Yeah.
but that was the only 10b-5 material that we
Yeah.
could discuss there.
Yeah. Based on what we knew. Yeah. But I mean, now next week you'll learn about insider trading, and then the question is, is there a duty of confidentiality, and who, in the classical theory, the misappropriation theory, and this is really getting to the trading. So the distinction is that the 10b, it's not 10, it's 10b, right? Think of it as a fraud on the market. We haven't done fraud on the market, but it's that in the hypo, the company didn't disclose. Okay, so there's a basis of liability against the company for failing to disclose the policy change, and then there's potential liability for misconduct, like under insider trading liability. So that is distinct. That is not a disclosure question. Well, the safe harbor has to be the safe harbor, right? Yeah, so the conditions of the safe harbor have to be met. If they're met, then you're maintaining it. But again, it wasn't clear that was entirely clear because there was a present statement. I wasn't thinking of the branch if the safe harbor applies. Then the question is, update the public when you have another conversation.
Right. So if you have like a big check, right, and you don't I go to whatever section 11. Rarely do I go to Stanford.
The company is continuing to mislead. That makes sense?
Yep. Thank you so much.
Can you walk us through that?
And then the panelist has one stray microphone without a stand. I think those are probably for like minor.
Here's like kind of far, but it's also next to where
We could, yeah, I guess that's fine.
Yeah, well, like we're just setting it.
It's like no.
There's like not enough room
For all of the firms, yeah. Because they all have flyers too. We're going to scoop the whole thing.
Yeah, we're just gonna keep the flyers with the firm, right? Or we can put them on a separate table.
No, leave it with the.
First two for this time.
And then we can like refill throughout as necessary. And then we have 9 people. two on that edge. Okay, let's do that. Wait, but then what are the notices?